In this video, we are discussing the decision of the Clerk of the National Assembly preventing Senator Natasha Akpoti Uduaghan from resuming after 6 months suspension. It's all over the media space. The letter from the Clerk of the National Assembly is all over the media space, and people are already talking about it very seriously. And so it begs the question, what are the reasons given by the Senate for refusing her to resume? Now, what says the law? Because the Senate is a creation of the law, suspension was also supported by law, right? The rules of the Senate. So what says the law regarding the resumption of someone that was suspended, a member of the National Assembly that was suspended? Is the Senate right in this, their decision? Okay, the clerk is representing the Senate. Is the clerk right? Is the clerk wrong? We look at all that in this video. It all started with Senator Natasha writing a letter to the Senate informing the clerk that the 6-month suspension is over and that she should be allowed to access her office. And this is the letter written by Senator Natasha Akpoti. The letter was received by the office of the clerk on the first day of September 2025. She has given a background to writing this letter. She has given requirements for immediate access to her senatorial office to enable her to go back even before the recess and attend to the things that have been lying fallow in the last 6 months. She has given legal opinions. She has given formal demand to the clerk to allow her to resume on the 4th day of September, and then a conclusion. And the letter is signed by her, yours faithfully, distinguished Senator Natasha Akpoti Uduaghan, Senior Advocate of Nigeria. I never knew that Senator Natasha is a Senior Advocate of Nigeria. But obviously, that's a typographic error. The letter is copied to the President of the Senate of the Federal Republic of Nigeria. And following that letter, the Clerk of the National Assembly replied. And the reply was dated, 4th day of September 2025. That's the day that Senator Natasha wanted to resume. It's addressed to Senator Natasha. There is no SAN. The name is written without SAN. So which means the clerk understands the fact that the SAN was just a mistake, a typographic error. It says, and there's need for us to read this letter so that we understand exactly what's going on. Notice of resumption. I am directed to acknowledge the receipt of your letter notifying this office of your intention to resume sitting and other legislative duties in the Senate on the 4th day of September 2025, which you claim is the date of expiration of the 6-month suspension imposed on you by the Senate. The letter goes on to say, I am further directed to inform you that your suspension was with effect from Thursday, 6th March 2025, and draw your attention to the fact that the subject matter of your suspension, notes, is presently before the Court of Appeal. The matter, therefore, remains sub judice, and until the judicial process is concluded and the Senate formally reviews the suspension in the light of the court's anticipated judgment or pronouncement, no administrative action can be taken by this office to facilitate your resumption. I'm calling it anticipated because at the moment there's no judgment. It is expected, okay? So no one knows when it's going to be given. You will be duly notified of the Senate's decision on the matter as soon as it is resolved. Please accept, distinguished Senator, the assurances of my highest regards. Signed, Yahaya Dan Zaria, PhD, Esquire, Acting Clerk of the National Assembly. Esquire here would presuppose that he is a lawyer. That means he understands the law and also understands legislative proceedings, right? Now, the clerk's reason, as you have seen in that letter, is that an appeal is pending at the Court of Appeal. And until that appeal is determined, nothing can be done regarding the lifting of the suspension. Now, what says the law? And this is very fundamental. What says the law? Does an appeal preclude Senator Natasha from returning to her seat in the eyes of the law? Does it? Here is the answer. The answer is no. Absolutely no. The appeal can go on without affecting her return. Appeal does not stop her return. It doesn't. Now, why do I say so? Her suspension was for a term certain, 6 months. 6 months. That is what her suspension was about, 6 months. It was without any additional conditions. We never heard of any additional conditions. There was nothing like, if you go on appeal, you're going to wait until the appeal is determined before you can return. The suspension from the word go was for 6 months. 6 months is a term certain, right? Now, she was simply to stay off the Senate for 6 months. Upon her completion of the 6 months, the suspension abates naturally and by operation of law. Why? Because she was asked to go for 6 months. 6 months is over, so it abates naturally and by operation of law. So by law, Natasha has done what the Senate asked her to do and ought to be allowed to return to the Senate as the Senate resumes from recess. You ask her to go for 6 months. 6 months is over. By law, by operation of law, she has served out her term, her suspension, and ought to be allowed to return. Does an appeal preclude a person from continuing in a public office? The answer is no. Appeal is a judicial process recognized by the Constitution passed by the National Assembly, right? And the process must be allowed to evolve. Appeal does not stop anyone from continuing in a public office. As we speak, for instance, the National Assembly also has appeals in courts. It's either people have sued the National Assembly or the National Assembly has taken up an appeal to the Court of Appeal or to the Supreme Court because the National Assembly is dissatisfied with a decision of a court. And so the National Assembly has cases in the appellate courts. But does that stop the National Assembly from sitting? No, it doesn't stop them. The Senate continues to sit while prosecuting the appeals. The appeals go in pari passu with everyday activity of the Senate. It doesn't disturb the Senate from functioning. It doesn't in any way. The Senate continues to prosecute its own appeals until such time that the appeal is determined. Now, it should be noted that except that there is a specific order of the Court of Appeal restraining Senator Natasha, except there is such order as we speak, restraining Senator Natasha from resuming, you cannot stop Senator Natasha from resuming because there is an appeal. There must be that specific order of the Court of Appeal restraining Senator Natasha from resuming until the appeal is determined. That way, the Clerk of the National Assembly will be justified in saying, I am going by the provision, I am going by the determination, I am going by the order of the court. In the absence of any such specific order, appeal on its own does not automatically restrain Senator Natasha from returning to her seat. Now, let's look at a practical example. Okay? Someone is sentenced to jail for 6 months by a court in Abuja, right? He is taken from the court to Kuje prisons, direct. He stays there. And while staying there, he is very dissatisfied with the decision of the trial court. And what does he do? He briefs his lawyer to go on appeal. The lawyer files notice of appeal, files brief of argument, and then argues it, okay? Serves the brief of argument on the other party. The other party also files its own reaction and then waits to argue it. And the person stays in prison, expecting that his appeal is going to be heard within 6 months for him to go, for him to be exonerated. And the court is unable to hear the matter within 6 months. And the person serves out the term. The question is, can the prison authority stop him from going out of prison because there is an appeal filed by him, which is yet to be determined? The answer is no. The person goes home. Once he has served out his jail term of 6 months, he goes home. Whether the appeal is determined or not, he goes home because it is not his fault that the appeal has not been determined during the pendency of his term. So once he serves out his term of 6 months in jail, the prison doors are opened for him to go. I'm not saying that Senator Natasha's own is akin to a prison. I mean, Senator Natasha was not in prison, right? I'm just giving a practical illustration. Once the person serves out the jail term, whether appeal has been determined or not, the prison door is opened for him, and then he goes home. So, is the clerk right in his decision, in his letter of September 4, 2025? My answer is that he is not right. Dear clerk, your decision in that letter is not right. It's not supported by law. It's not even supported by the rules of the Senate. The clerk needed to consult widely before the decision in the letter. Good enough, I have seen Esquire in that letter. Okay, so that gives me the impression that the acting clerk who has written that letter is a lawyer. And so the clerk should understand the fact that there is no law supporting the position in that letter. Remember that we are dealing with an institution that makes laws. And so that institution must also abide by the law. There is no law that says that since Senator Natasha has an appeal, she cannot be allowed to resume. The decision of the acting clerk is not supported by law, not even by the rules of the Senate. His decision would be tantamount to punishing a citizen for approaching the courts. That's not allowed in a democracy. Every citizen of the country is allowed to go to courts. The Senate goes to courts. So if you stop Senator Natasha from entering the National Assembly because there's an appeal, it is tantamount to punishing a citizen of the country for going to court. And that's not allowed in a democracy. There is yet another question of whether it was even necessary for Natasha to write the letter in the first place to the clerk. Was it necessary? My take is that the letter was not necessary. She even made legal arguments in the letter. She mentioned the appeals. So she even gave out her matter to the National Assembly. Oh, so there's an appeal. Okay, we hang on this. So the letter was not necessary. It wasn't. Senator Natasha is done with the suspension, which was for a term certain, and the term is 6 months. And all she needed to do was to wait for the resumption date and proceed to resume her seat with her colleagues when the Senate resumes. So for me, the letter was not necessary. It wasn't necessary. It's not every time you write letters. It's not necessary. Now, what are the options for Senator Natasha at this point? What are the options? She can decide to withdraw the appeal. Just let everything go. Let her have her peace. She can just decide to withdraw the appeal, call her lawyers and say, the appeal should be withdrawn. And the appeal can be withdrawn at any time. Once you file notice of discontinuance, you can withdraw the appeal. She can also decide to continue the appeal to the end. And if she does that, she has not broken any law. Absolutely no law has been broken if she continues it to the end. Now, appeal is a right available to all citizens of the country. The appeal is also available to the Senate. Appeal is available to every senator. Appeal is even available to the clerk. Every citizen of the country. If you are aggrieved, you go on appeal. Okay? So it's a right. So she can decide to stay on in the court of appeal until the appeal is determined. Now, the determination of the appeal filed by Senator Natasha Akpoti Uduaghan should also be seen by the Senate to be something that will guide the institution moving forward as to a lot of issues. The issue of how many months a senator can be suspended, how many days a senator can be suspended, all the issues in that appeal. I'm sure it will also be beneficial for the Senate in streamlining, the issues that are currently very highly debated among several scholars, among several persons in the country. What's my suggestion at this point? What am I suggesting? I suggest that the clerk should reconsider his position and allow Senator Natasha to return to her seat. Natasha's 6-month suspension having been fully served out and having come to an end. So the clerk should reconsider, his letter. Now, before Senator Natasha can be precluded from resuming, the Senate will have to pass another resolution suspending her a second time. That's the only way the Senate can stop her. But note that before you can pass a resolution suspending a senator, the senator would have been on the floor of the Senate, in the plenary, and then you suspend the person there. So, before the Senate can tell Senator Natasha Akpoti to come in, there must be another resolution suspending her. For the one that she was suspended in March 2025, Natasha has served out that suspension. And in the eyes of the law, there's nothing stopping her from returning, and she should be allowed to return to the Senate. Thanks for watching. Continue watching this channel and sharing it with your friends and loved ones. The discussion continues as the events unfold. I'm here to give, flesh to the discussion as the events unfold. Many